If you've been to a movie lately, it's likely you've seen the preview of Captain Phillips. It's an upcoming film starring Tom Hanks about the real-life ordeal of an American cargo ship captain held hostage by Somali pirates. Unlike the lovable rogues played by Johnny Depp and Orlando Bloom, real-life pirates are desperate and deadly, and an increasing number of them are children. In this broadcast of Talking Foreign Policy, we've assembled a panel of the world's foremost piracy experts to discuss the continuing challenge of maritime piracy. I'm your host, Michael Scharf. We'll begin our show with a conversation with General Romeo Dallaire, best-selling author and famous UN commander. Together with the other experts, we will be providing a unique insider's view on current efforts to combat piracy. Welcome to Talking Foreign Policy. I'm your host, Michael Scharf, Associate Dean of Case Western Reserve University School of Law. In today's broadcast, we'll be discussing the persistent problem of maritime piracy. We'll begin our discussion with General Romeo Dallaire, the UN force commander who tried to save the Tutsis during the 1994 Rwandan genocide. Nick Nolte played him in the award-winning 2005 film Hotel Rwanda. Since then, General Dallaire has been appointed a Canadian senator, written 2 best-selling books, and is the founder of the Romeo Dallaire Child Soldier Initiative at Dalhousie University in Nova Scotia. Thanks for being with us, General.
Thank you.
I'd like to start off by asking you to tell us a little bit about your journey from UN Force Commander to human rights advocate, focusing on child soldiers.
It was very much based on the experience in Rwanda. Previous to that, I was a NATO commander, so we were essentially engaged in classic warfare, the end of the Cold War. All these new imploding nations and failing states got us involved in a number of countries. And so the Rwandan mission that I commanded, which ultimately ended with the genocide in Rwanda, brought me face to face with the ability of human beings to be able to destroy each other on massive scales and with near impunity, and also the use of youths and children in that same ilk, that is to say, using youth militias to conduct a lot of this destruction. And so those traumas of 1994, I was able to then nurture this feeling that there had to be something better in the world than simply letting these catastrophic failures happen. And so I got engaged in trying to get back into the field and trying to prevent some of it from happening.
Now, you've written 2 best-selling books. The first one was Shake Hands with the Devil, and it's a powerful indictment of the international community's inaction in the face of genocide in Africa. Do you think the world has learned the lessons from Rwanda now that it's been 20 years later?
It's interesting the way you put it in a professorial way. You know, they learned the lesson. I think they learned to create some tools that would prevent that from happening. As an example, and I think the dominant example is the responsibility to protect doctrine that was finally approved in 2005 to General Assembly, which essentially the world signed up to, which says that if a nation is massively abusing the human rights of its own people or can't stop it, all the other nations under the UN must go in and intervene to protect. So that was an extraordinary product that was brought about. The problem, however, with that is that although they've learned that and they know what's there, they're not applying it. They're not operationalizing it.
So, for example, Syria, right? That's Obama has been saying we have to go in for humanitarian reasons, and other countries and members of our Congress here in the United States are saying it's not legal to do so and we have no obligation.
Well, and both are wrong. In fact, it starts as far back, or not that far back, as Libya, as we went in sort of half-cocked with sending in the air forces, where in fact, when Gaddafi said, I'm going to crush these cockroaches, those were exactly the same words used by the extremists in Rwanda that brought about the responsibility to protect, and we should have put boots on the ground to protect the civilians and ultimately not have them bleed in trying to reestablish some order. Well, Syria offered us exactly the same situation, but we didn't take it up. And so when I was asked 2 years ago, which was already 6 months into the Syrian campaign, what do you think we should be doing? I said we should be applying responsibility to protect, but there haven't been enough people killed to actually provide the politicians in this world who have the ability to intervene to want to intervene. So the will to intervene is not behind the responsibility to protect.
Now, in Rwanda, we were talking about 800,000 people who were killed. In Syria, the recent estimates were 1,400 people were killed by a recent chemical weapons attack, but maybe 100,000 people have been killed. How many do you think would be enough before the scales tip in favor of some kind of humanitarian intervention?
And that's, you're hitting the heart of the problem. How many humans have got to suffer for those who have the capability of responding and considering those human equal to them to be worthy of us taking those risks and going in and helping them? And we haven't broken that code. We've found means of maybe how we should do it, but we haven't found the willingness of our leaders, who are politicians, which are risk averse, are not statesmen who would be prepared to take risks, demonstrate flexibility, demonstrate a lot of willingness to move to a higher plane than self-interest. Those statesmen aren't there. And so that's why we're into number crunching. And to be quite honest, the recent gas attacks, chemical attacks, it's a crime against humanity. Fine, bring in the International Criminal Court. But that is not the red line. In reality, if we are responsible towards the responsibility to protect, red line was 2 years ago.
Oh,
and so we didn't intervene now, and now it is nearly impossible unless you get a ceasefire and move in a separation force under the UN to permit then a negotiated future stage.
Let's now talk a little bit about child soldiers, because that's what you've been focusing on lately. Your recent bestseller, They Fight Like Soldiers, They Die Like Children, is about the problem of child soldiers. And you make the case that the international community is ignoring that problem at its own peril. Can you elaborate on that?
It's because it's very much peer-focused. Many of the nations that are seeing the use of child soldiers, either by government forces and structures or non-state actors, are countries where the demographics are such that 50%, sometimes more, of the population are under the age of 18, which is the age under the optional protocol of child rights, where children are not to be recruited nor used in operations in conflict. And so you've got this massive reserve of youth that is being abused, and they're seeing each other being so used, and it sort of can perpetuate itself because, I went through it, and so, maybe this is the way we can do it, and let's keep it going. And so there's the greatest risk of the child soldiers is the fact that it can be an instrument of war, a weapon of war that can sustain itself ad vitam aeternam.
Yeah.
Because the demographics are permitting it to happen.
And you've gone from looking at child soldiers to now even focusing on a narrower type of problem, but related, that of child pirates, maritime pirates. So your recent editorial in the Toronto Globe and Mail was headlined, "Child Pirates Are Everybody's Problem." Can you tell us why we should be concerned about child piracy?
Because the impact of them is, of course, an economic one that is directly related to our self-interests, of our economic self-interests. But also the child piracy has this funny way, in my perspectives, of going beyond its borders. This is not a border-restricted use of children, like, let's say, child soldiers, which would be in a nation, a conflict zone. And apart from the LRA, who have been sort of very mobile.
That's
most
the
of them
Lord's Resistance Army in Uganda and Southern Sudan.
Who are now up in Central African Republic and probably being supported by Sudan to maybe ultimately subvert South Sudan. So, it gets pretty complicated in those. But apart from that particular group, the others are very localized. And so the question is, with pirates, it's not. It spreads. And so we're seeing now the Western Africa also seeing a surge of the use of piracy and the availability, again, of youths who can be given empowerment by weapons
So what
and by
percentage of
indoctrination.
the pirates are children, would you say? Is it like half?
Well, the figures seem to be about a third or so.
Okay.
But imagine when they're on the seas, and you've got people on big ships, naval ships or other ships, and they're protecting and they're opening fire. Are they able to discern whether or not this is an adult or a youth? And so what we're seeing are a lot of these kids being killed.
Yeah. And when they do discern who is a child and who's an adult, many of the countries have a policy that's sort of like the fishing policy. When you catch a fish that's too small, you have to send it back. So they call it catch and release. Do you think that that is the right way to be treating the juvenile pirates?
Absolutely not. In fact, the link that brought us into child piracy comes from child soldiers, which is what is happening on the ground before they're actually deployed. I mean, if on the ground you've got an atmosphere that permits this to happen, the recruitment, the re-recruitment of it, of course they're going to go at sea and then you've got a problem. So how do we curtail it on the ground? And I am a strong advocate for a non-punitive juvenile type of court process in which the youth are taken. They're not incarcerated, they're held. And in the process of this non-punitive juvenile court, they are given the opportunity of being rehabilitated and reintegrated and ultimately being able to be extracted from that cycle of, if not banditry and piracy, maybe even conflict and fighting if a conflict erupts.
What about the adults? What can be done to discourage them from recruiting the children?
Take every one of them and throw them in jail and throw away the key.
Okay, so in fact, what we're hearing is some courts around the world are increasing the penalty when an adult pirate is found on a ship with children. It's time for a short break. When we return, we'll bring three of the world's leading experts on piracy into the conversation. Stay with us. Welcome back to Talking Foreign Policy, brought to you by Case Western Reserve University and WCPN 90.3 Idea Stream. I'm Michael Scharf, and I'm joined in studio by General Romeo Dallaire, Judge Rosamel Matuka of Kenya, Piracy Prosecutor Reshma Bikari of Mauritius, and Professor Milena Stereo of the Cleveland Marshall College of Law. We're talking about the problem of child pirates. Let me begin with Reshma Bikari. To prepare for your first piracy cases in Mauritius, I understand that your government studied the best international practices and adopted a state-of-the-art approach. So walk us through what that means. What does your government do when an accused pirate appears to be a juvenile?
I have to say we have not faced that issue in practice yet, but it's an issue which is expected, and guidelines have been discussed, a draft put up but not yet finalized with other states of the region, and that is Seychelles mainly. Now, these guidelines would include what to do in that kind of situation and how to determine age, going from teeth examination and a lot of other medical ways of ascertaining the real age.
And that's because everybody they catch, knowing that there's often a catch and release policy, will say, I may have a beard and a low voice, but I'm only 14, right?
And how do you know who's speaking the truth and who isn't? But I feel as well that the decision might come much earlier. It might impact on a decision whether to accept a transfer or not, where juveniles are involved, but it remains to be seen in the future.
Now, Judge Rosamel Matuka, you've been in the United States as a distinguished professor and visitor at Case Western Reserve, and we're glad to have you back in Cleveland. You have presided over 7 piracy cases in Kenya. Were any of those juvenile cases?
Thank you, Michael. Yes, I've presided over 7 cases. I concluded 3. And unfortunately, none of the 3 that I concluded had any juveniles. But at least 2 of them had juveniles. I took plea in 2 cases. And it's not very common for them to want to claim that they are juveniles. In fact, they avoid to say that. And you perhaps just want to look at them and perhaps because of their size and the way they appear, then you perhaps then think maybe you should take them for age assessment, because they will not tell you. That was not my experience.
Now, that's very interesting. So where I thought everybody would want to claim to be a juvenile, either because they are fearful of the pirates that hired them, or for other reasons, they actually are all claiming to be adults when you suspect they actually are underage.
It's interesting, and I think the reason is because, and it became evident later, of course, when they come in, we have challenges. One of the main challenges we had is communication, because, of course, they speak Somali language and, they can't communicate with you. But what became evident to us later was the fact that they did not want to be separated. They knew if they were juveniles, and they'd be taken to a juvenile detention facility. That meant that therefore they would be kept away from the others, which they did not want to. So they would not say that they're juveniles.
Now, from our conversations, I know that you had all sorts of special care for these pirates. You sent them to special prisons, not as part of the regular population. You helped educate them so that if they were illiterate, they could learn a language. What was your thinking on that?
In fact, it is because we had juveniles among them, and that was a consequence of getting them separated from the other prisoners in the remand facilities. And we did that deliberately because we wanted to make sure that the children and the juveniles among them were protected. And it was easier to do that because, of course, first of all, like I said, the issue of language. And so it was, if you had them together in one place, then it was easy to arrange for an interpreter to be with them and to be able to communicate with not only just among themselves and the prison authorities, but also when they had people visiting, because there was a lot of interest in these cases, and we had a lot of people coming from all over the world. And so it was easier to deal with them in ensuring that, once, if they are put in one place, then, facilitating that communication was easier.
How long were the sentences usually?
Interesting. The first case that we had, of course, the first case registered in Kenya was 2007. The first conviction was in 2009. And each one of them was sentenced to serve 20 years imprisonment. And immediately they appealed. But then subsequently, they got sentences between 5 and 7 years. And right now, that seems to be the trend. And that case is still pending appeal. But there's one other case about 2 years ago where the sentence to serve 20 years. And the only reason is because people died. There were people who died as a consequence of their acts of piracy.
I mean, so they were murdered. They were convicted of murder.
No, not murder. They were charged with piracy, not murder.
Okay.
Because
but the victims actually died during the attack.
Yes, they did.
Okay. And when these pirates are in the Kenyan jails, as part of rehabilitation, you do educate them. You teach them to read and write. Is that part of it?
Yes, it's part of it.
So
yes.
let me ask this. It's been said that short sentences and decent jails, 3 square meals with educational opportunities is not much of a deterrent for people facing famine in their own country, like the Somalis. Some have even compared the treatment of the Somali pirates in Kenya, in the Seychelles, and in other countries as going to university. Is that a fair criticism?
Well, I do not agree with that. I think that is a very simplistic approach to what has been done. Actually, when you think about the fact that, in Somalia there was, and perhaps now they're building it up, but there was a complete breakdown of law and order. And most of these young men that are that are used to commit piratical offenses are not educated. And so they look for something to do. So if you take out, it doesn't matter how many numbers you take out, there are so many others that are still available. So it's not so much the fact that you think you're going to pass a message to people who really don't care. They're looking for a livelihood. So for them, that is collateral damage. You move on. So I think that argument is kind of simplistic when you look at what's happening in Somalia.
So prosecution is not really going to deter anybody, no matter what the penalty. In the U.S., they've given some life sentences, for example, and the prosecutors in their closing arguments said, we need to give them the most serious penalty. In fact, they were asking for the death sentence in order to send a signal back in Somalia that piracy won't pay. And what I hear you saying is they're not listening in Somalia. It doesn't matter what signals the prosecution is sending. That's not being heard by the populations that are resorting to piracy.
I'm not saying that it's not effective. I do believe, of course, that it may be a deterrent, but I don't think it's a deterrent to the extent that you'd say that if you give long sentences, then, of course, that would stop them. Because, of course, these are desperate young people who are looking for a livelihood. So my argument is that, and my experience, in fact, is that, they are contrite about the things that have happened. If you talk to them one-on-one, they'll tell you that. And most of them who have been sentenced by Kenyan courts have tried to get something else to do because, of course, now after educating them and talking to them, they feel that there's something else they can do with their lives. And Somalis are enterprising people. They are very hardworking people.
Now, do they do their new jobs in Kenya, or do you send them back to Somalia?
They usually send back to Somalia, but Kenya has a unique situation where we have Somalis, and then we have Kenyan Somalis. And of course, the only difference between them and the Somalis and Kenyan is the border. And they speak the same language. So, whereas we make orders for repatriation, and they are sent back, but the systems we have in place do not ensure that they go back and stay back in Somalia.
Let's bring Professor Milena Stereo into the conversation. Milena, before the break, General Dallaire gave us his prescription for solving the problem of child piracy. And we've just heard Rosamel's discussion of how Kenya dealt with child and youthful pirates. What would you add to that? And do you agree with the approach that they're enumerating?
Yes, I do agree with the approaches, and it would be great if either one of us could say or do something that would in the short term solve the problem of child piracy, right? That's not the case, unfortunately, but we can certainly offer, best practices or recommendations. So I think the proper approach is definitely trying to ascertain the suspected pirate's age from an early stage so that they could be appropriately treated, separated from the adult population, and provided with those educational opportunities. When it comes to the prosecution and then the sentencing, the age of the suspected defendant should definitely be taken into account. And then once we're talking about sending them to an appropriate, correctional facility to serve their sentences, they should definitely be sent to a facility for juveniles where those educational rehabilitation opportunities are present. It might be easier said than done. But
how do we know what the line is between a juvenile and an adult? Are we talking about 18 years of age?
So there is really no consensus in the international community as to the appropriate age of minimal criminal responsibility. There is a United Nations convention called the Convention on the Rights of the Child that defines a juvenile as anybody who is under 18. So under that convention, the minimum age would be 18. However, when it comes to the prosecution treatment of suspected juveniles, it's ultimately up to each country in its own domestic juvenile system to determine where we set that minimum age of criminal responsibility.
So where do we set that in the United States?
So in the United States, it really depends from jurisdiction to jurisdiction. It can the minimum could be as early as 7 or 8. In some jurisdictions, the prosecutors will have the discretion to charge somebody as an adult or not. But certainly in the United States, when somebody's 15 or 16, many times when it comes to violent crimes, we treat them as adults.
So in particular, those people who are older teenagers, 16, 17, 17 and a half, they are, under the current approach, being treated as juveniles. And the current approach seems to be very black and white, very rigid. Are you advocating a looser approach where you look at facts and circumstances like they would do in the United States?
Well, if you adopt an approach that says that you should take the person's age into account, into consideration, that gives you the flexibility to then say, if you're 13, we'll give you a lighter sentence. If you're 17, which is really much closer to 18, however arbitrary that age might be, we might give you a slightly harsher sentence.
Okay. Now, looking at the other side, trying to not deter the child pirates, but deter the people that are recruiting and using them, I wonder if we can go back to General Dallaire and focus on what they do to deter child soldiers. One of the things is the international criminal courts have been prosecuting the recruitment of child soldiers as a crime against humanity. Is that right?
They have, but it's been a long long glacial exercise to get those first convictions in front of the court. But it's also been very difficult to get the court to fully grasp the impact of these children when they're recruited in order to establish the right level of punishment to be given to the adults. And one of the reasons why it's difficult to establish that is that when you're bringing these children in as witnesses, or they're just out of, they're young, 19, 20, and the court is in Den Haag, and so there's a whole exercise of that. But the defense are very, very powerful. And the defense lawyers are just taking these witnesses apart. And as they're ripping these witnesses apart, because they've gone through, the girls especially, they've been raped, they've been abused, they probably have a child or two, they're probably even sick with AIDS and the like, they are destroying their ability to provide you with a sustained, logical explanation of what has happened to them. And that weakness has permitted, as an example, in the recent convictions in the ICC, to not convict one of the leaders, if not two, but I know one, of rape, where we know the individual was engaged in rape on a series of occasions, but they just couldn't get that proof to the satisfaction of the court.
Right. So you refer to the ICC, that's the International Criminal Court, and the case you're talking about is the Lubanga case.
Very good.
They ended up convicting him, though,
Yeah.
of recruiting child soldiers.
Yeah, but he only got 14 years.
Okay.
And the guy's been using all kinds of children, and he's been slaughtering and killing and using them as we were using World War I soldiers, in frontal assaults and having them blow away. He's been throwing kids back into the bush when they're injured, when they're sick. I mean, the scale of what this individual has done, is off any of our scales. But he ends up with only a 14-year sentence.
So you're saying that case did not send the signal that
not
you
strong
wished
enough
it
yet.
had. Okay.
It's a start because we finally got it there. Right. But the handling, how we can handle this, is not resolved. How can we protect the witnesses so that they are going to be credible in front of the court to be able to bring the right sentence?
Now, when countries like Mauritius and Kenya and the Seychelles that are in the area are prosecuting the pirates that the United States and the European Union and the Canadians are apprehending, they often are prosecuting not just under the crime of piracy as defined in the UN Law of the Sea Convention, but sometimes under other terrorism conventions for like hostage taking and hijacking of a ship. Do you think they should also prosecute for crimes against humanity using the precedent of the International Criminal Court's conviction?
This is a great opening, I think, to the maturing of the whole international judicial system of the globe, of humanity, in as much as can, in fact, crimes against humanity be recognized by nation states and be mandated to actually prosecute under that international law versus the International Criminal Court? I say absolutely. We recently in Canada prosecuted a genocidaire from Rwanda, but it wasn't. We didn't get him under a crime against humanity. We got him under several killings and the like. And he wasn't really held as a genocidaire either. It was more because instigated a lot of these actions. I think that crimes against humanity means that all elements of humanity should be able to be held accountable to it, and that we should have judicial systems that will meet that and mature with time.
Well, let's then go back to our prosecutor from Mauritius, Reshma Bikari. Would your country be able to prosecute crimes against humanity? Do you have that crime on your books?
Interestingly, I think our thinking has gone in that direction, but with a slight variation. What we did 2 years ago is we reached an agreement with the ICC, whereby the ICC will be coming to sit in Mauritius and have those crimes prosecuted in our local courts. And we actually enacted a piece of legislation called the International Criminal Court Act 2011 in Mauritius. And for us, even that is a novel idea. We haven't really quite reached the kind of thinking you're mentioning, Professor Scharf, but I think we could give it thought, but it will take quite a bit of thought.
So there is the possibility that if Mauritius finds itself with a major recruiter of child pirates, that you could prosecute that person not just for piracy, but maybe for the crime of against humanity of recruiting child pirates, like the ICC has done for recruiting child soldiers.
Possibly. I would think the seed for that has already been sown when we've already opened the door for the ICC to come and sit locally, and for us to start looking towards bigger crimes, which up to now have only been prosecuted in The Hague, being prosecuted down there in the region.
Now, there is one little wrinkle here, and that is that piracy is normally, as I understand it, a crime committed in international waters on the high seas.
Yes.
But where's the recruitment being committed? That's on dry land.
Yes.
So is there any precedent, and I'll turn this to our professor from Cleveland State, Melina Stereo, is there any recent precedent for prosecuting dry land piracy?
Yes, we actually have very interesting, important precedent in the United States courts recently. 2 cases, one called Ali, the other one called Shibin, where the defendants were essentially prosecuted for aiding and abetting piracy, essentially facilitating piracy, acts that they committed from dry land. And they were prosecuted under the United States piracy statute, and one of them was convicted and received a life sentence, and the other one, they're still, the proceedings are still ongoing. But in both instances, our United States courts have accepted this notion that you can commit acts of facilitation on dry land and be prosecuted as a pirate.
So tell us about this Ali case. What was he actually doing?
So Ali was essentially a hostage negotiator. He had, after there were hostages taken by Somali pirates, he had facilitated the negotiation of the ransom, and he, I think, had stepped foot on board the vessel, but the vessel at that point was in the Somali territorial waters. So Ali, the defendant himself, had never acted on the high seas. And then he had committed other acts of negotiating the ransom from Somalia, from dry land.
And wasn't his defense that he was actually trying to facilitate the rescue, the release of the victims?
Yes, he basically claimed that he was a good guy since he was trying to help the release of the hostages. Of course, United States prosecutors did not buy that argument and prosecuted him as a piracy facilitator instead of a hero.
Well, what's the difference between that case and the insurance companies? I understand what happens in piracy cases is that if you're insured by Lloyd's of London or something and your vessel is hijacked and the pirates say, we want $1 million for the release of your vessel and its crew, Lloyd's of London send in a hostage negotiator who goes in and handles everything, and they pay it off, and then maybe they jack up your insurance premium, and everybody lives happily ever after, especially Lloyd's of London, who's making a fortune.
Right.
Why shouldn't Lloyd's of London be prosecuted under the Ali precedent?
Right. I mean, there is a word in there in the United Nations Convention on the Law of the Sea, the article that deals with this issue of aiding and abetting piracy. You have to intentionally facilitate. So I guess for the insurance companies, you could make the argument that they're not really, intentionally doing anything, and if anything, they're helping after the fact. But I agree with you that it is a fine line.
Okay, and this guy Ali, I've heard it said that he was the highest level pirate prosecuted in modern times. Is that right?
That is right. And by the way, the Ali case is the only universal jurisdiction of piracy in the United States courts, meaning Ali had no nexus, no connection to the United States. The victims were not American. So it's really a fascinating case.
So the highest level guy is just a negotiator. No kingpins, no financiers, no top people been prosecuted?
Well, not yet, but this, I think, opens the door for those kinds of prosecutions, at least in the United States, because now we know that in U.S. courts, if you commit acts on dry land of aiding and abetting piracy, facilitating piracy, and that could be financing a future pirate attack, you can be prosecuted for piracy.
Well, and Judge Matuka was saying earlier that they've only been prosecuting the foot soldier pirates that they capture, and she's not absolutely sure if there's a deterrent effect. Well, I guess if these people are fungible and they're just the foot soldiers, it's sort of like trying to deal with the narcotics trade by just going after the mules. And what we learned in that area is until you started going up to the leaders of the cartel, you weren't able to make a big difference. General, what does that say to you about our strategy for combating piracy? Are we going about it all wrong, just plucking the foot soldiers off from the vessels and prosecuting them?
I think that there's got to be concurrent activity, and that you simply don't want to continue to permit these, particularly in the case of child soldiers, child pirates, to continue to be recruited and to be used, and they become the casualties, and we meet as best we can what solutions, judicial solutions for them. I think you've got to keep at that to make a responsible action in that regard. However, where we're failing is giving teeth to the nations and the International Criminal Court as an example of being able to go after the bad guys. And it doesn't have its own police. And if they're in a nation that is a failing state that doesn't have a rule of law or a basis for wanting to go after those guys, how then do you get into a sovereign state, go after them, and then haul them out? And so there's where there's a nuance that I think has not yet been pursued. And that comes from the fact that when we introduced the responsibility to protect doctrine, we essentially said, and this is all the way back to Westphalia, 3 centuries ago, we essentially said that sovereignty is no more an absolute. Justice is an absolute, love is an absolute, and sovereignty used to be an absolute. Now it's not. Now we can go in for a good reason. And I would argue that in certain cases like that is affecting the international community, we should find a means, either through giving assets to the International Criminal Court or by some other judicial, innovative international means of actually getting people to go after the bad guys and haul them out.
Now, Judge Matuka, you've told me that the bad guys, the financiers, are living pretty openly and well in Kenya. Can you tell us a little bit about that?
Yes, actually, research done has shown that there's a lot of investment of piracy proceeds in Kenya. In fact, statistics show that there's about $2.1 billion that is invested in Kenya that cannot be accounted for, and of course it's then it has to be it has something to do with organized crime, and piracy is an organized crime. So
they're not investing it in the stock exchange; they're investing it in narcotics trade.
Exactly, and then in real estate, and then of course one of the things, the effect of them investing in that kind of business or venture is that they have to use illegal means. So there's a lot of bribery for them to be able to get licenses, for them to be able to do what they're doing. So in fact, it shows that there's a lot of the Kenyan economy is affected very negatively eventually.
But your government's not. It doesn't seem to be doing a lot about these pirates that are living openly, driving these great Rolls Royces or whatever, living in the big mansions.
Well,
How do you explain that?
Yeah, that is true. And in fact, I think it is because of a need to do something about it that the Chief Justice in my country decided that we were going to set up an international crimes division. And because he said that one of the main reasons why we're setting it up is because he said that the economy was mortally threatened by international related crimes. And of course, this division is going to deal with all manner of international related crimes, including piracy and trafficking and narcotic trade and so on. And I believe that through this effort, then, of course, then the obligation will fall on the law enforcement agencies to do something about particularly money laundering, because that is where now you can be able to get a hold of this kind of investment in Kenya.
All right, so we've been discussing some interesting approaches to try to deter the pirates through going after the financiers, the money launderers, the recruiters. It's time for a short break. When we return, we're going to look about what needs to be done to prevent a resurgence of piracy when the anti-piracy naval forces have to depart the Indian Ocean, which is going to happen soon. So stay with us. We'll be right back. I'm Michael Scharf, and we're back with Talking Foreign Policy. I'm joined in studio by a former UN force commander, a judge who has presided over dozens of piracy trials in Kenya, the chief of piracy prosecutions of the island country of Mauritius and an international law professor. We're talking about the scourge of maritime piracy. Let me go back to our prosecutor, Reshma Bikari. In our final segment, let's step back, discuss the big picture. Reshma, you know the prosecutors from the Seychelles, you know them from Kenya, you know them from several other countries. You've been doing a lot of discussions to try to get the best practices for your upcoming prosecution. Do you think that these prosecutions all around the world are having a deterrent effect on piracy?
Deterrent effect. I understand from the discussions I've had that views are split on this. And I do not think there has been any study to give us a definite answer as to whether really these prosecutions are having a deterrent effect. I think some people have been quoting naval operations or the use of private armed guards as the real reason for a deterrent effect. So there is an issue there. But as far as I am concerned, my personal feeling is that they actually do, and prosecutions actually send out a very strong signal that impunity is not going to be allowed and that you will be made to pay for it.
In the last segment, Professor Stereo was telling us about some of the recent precedents in the United States. I wonder if Judge Matuka could tell us about what you considered your most important piracy judgments in Kenya.
That's an interesting one. I think it was the first one that I handled. It was a case where they had hijacked a Norwegian ship, and it was rescued by the Swedish Army. The Navy, Swedish Navy. And the most interesting thing, though, was when we went to court to hear, when the case came up for hearing before me. And so we had to have 3 sets of interpreters, a Somali interpreter for the Somalis, a Norwegian interpreter who would then communicate with the Swedish interpreter and then take it back to the court interpreter who would say it in English. It was very interesting. But that was one of the cases that I handled. And eventually I convicted them and sentenced them to serve 8 years imprisonment.
And how many in total pirates have been convicted in Kenya?
Right now, the statistics show that we have about 115. About 115 have been convicted. 77 are pending. 77 pirates, 17 cases in 77 pirates.
And then when those 17 cases are over, is it correct that Kenya is washing its hands of these prosecutions and walking away? Is that my understanding?
I would imagine that that's a correct summation. Because
why is that?
I think what has happened is that, of course, the prosecutions were based on understanding that was entered into between Kenya and the countries that perhaps would be affected by piratical attacks in the Horn of Africa. But we have not renewed any, not to my knowledge. We have not renewed any of the understandings that we had. And so far, I think the last case we had was last year, and to date, they have not brought any new cases.
Well, and let me ask, was there sort of a quid pro quo? Was the United Nations and the international community giving money to Kenya, giving assistance to Kenya in order to convince Kenya to take on these piracy cases?
I might not be able to correctly answer that because I am not too sure I know what went on behind the scenes. Of course, I only know what is on paper. But I do know that there was a lot of assistance that was given towards improving the infrastructure, and also technical assistance that was given to both the judiciary as well as the prisons and the police.
And is that money no longer flowing? Is that part of the calculus?
I do imagine that it's still there because we still have we still have interest that has been expressed in areas of training, especially of judicial officers, which therefore means that there's still some connection and some support that is given.
Let's go back to our prosecutor from Mauritius. Is Mauritius receiving international donor money to try to convince Mauritius to take on piracy cases?
I'm not sure I would make the link straight away that was to convince, but the transfer agreement with the European Union came with an assistance package fully related to the trials themselves. And mainly related to training of prosecutors and just having a secure courtroom with metal detectors, dogs, video link facility. That is how far the assistance has extended.
And Malena Stereo, you and I went to the Seychelles to assist in some piracy work, and we were told that the UN built a state-of-the-art prison in their national park. Is that right?
Yes, that's correct. I think there was a new prison, or at least a prison wing, where the suspected pirates were being held, and there was certainly assistance by the one of the United Nations offices with respect to the training of the judges, the prosecutors, the defense counsel, because as we all know, you're prosecutors, but the defense is also important, and so I do know that the international community there has been involved.
I mean, I'm sure it's not just the money that convinces countries to prosecute. For instance, both in the Seychelles and Mauritius, the visits and from foreigners are being negatively affected by the perception that they're pirates in your waters. So you have that interest as well. Is that correct?
We do.
Okay.
We do. It's affected the whole region, really, in a lot of ways, and you wouldn't want it to continue that way.
And now the U.S. has also been prosecuting pirates, as Milena Stereo has told us. But there was also a case that was really unusual. It's not your typical piracy case. It involved the Sea Shepherds. This is that vessel, the Bob Barker, that you see in the TV series Whaling Wars. It's the vessel that goes after the Japanese whaling fleets and tries to ram them to stop them from killing the harmless whales. And what happened in that case, Milena?
So the Sea Shepherds case was just recently decided in the Ninth Circuit here in the United States. And in that case, which was actually a civil lawsuit, in that case, the judge in the Ninth Circuit found that an organization, essentially a marine conservation organization like the Sea Shepherds, can be considered as a piratical, a pirate organization, as long as they're not operating on behalf of a government. So as long as they're operating for their own private purposes, it doesn't matter that they're not really sea robbers, right? They're doing that to protect the whales. But as long as they're committing these violent acts on the high seas, for the purposes of United States law, they can be considered pirates.
So Greenpeace, watch out, huh?
Yes, definitely.
All right. Now, we've been talking about prosecutions. We've been talking about precedents. But as our prosecutor, Reshma Bikari, told us, there's also the deterrent from the vessels that are out there patrolling the waters and the private security guards that the companies that own private vessels have been contracting with. Now, how many vessels would you say are out there? It sounds to me like there's an armada of U.S. and European vessels. General, can you tell us?
I don't have the figure, but I think you're quite right. It is a sizable fleet, which includes Chinese vessels and Russians. So it is a very polyglot fleet that's out there. The problem when you're using, however, the extreme measure in any conflict or in any situation when you have insurrections in your nation and so on, the extreme measure is using the military because it has a very definitive position to take, and it is not one that can be sustained in the long term because it's not your normal course of a nation to have your military always deployed in a security role.
It's quite expensive, isn't it?
Well, it's expensive, and it's not necessarily the most effective tool either. So when we moved all those naval assets there was obviously a recognition that this had a sort of finite time to it by the nature of the fleets that could be maintained there and the cost and the like. And so the question that never seemed to be coming to the fore, people have been avoiding, is what happens when they leave? Because they're going to leave. And so what you do fear is you leave a vacuum. So there's been these security companies and other arrangements being made. And I think that's where the international community fails. As an example, why isn't there a UN naval capability? We have UN land capabilities. When I was in Cambodia in 92, we had actually a naval capability in Cambodia in that mission to fight pirates in off Kampong San. So why doesn't the UN have that and have its own capability versus having to seek or potentially wait for donor countries to provide?
It sounds almost like this is the surge, taking an analogy from Iraq and Afghanistan, and maybe even going back farther in history when the U.S. sent the Marines against the Barbary pirates. And the hope was if we have enough military assets there, we will finally defeat the pirates, and then we can manage the situation on a lower level. But you're saying that that's not going to happen. When they pull out those assets, you think piracy is going to spike.
You haven't broken the back of the whole system.
Is it possible to do that without solving the failed state that is Somalia?
Well, in fact, there's where I come back to the whole question of sovereignty. If a sovereign nation, by its inept capabilities of being a failing state, is putting a whole bunch of other nations at risk, there is surely a means by which we can, through the International Criminal Court and international justice system, to mature to handle something like that. And that's why I've always felt that the international tribunals that led to the International Criminal Court, the Rome Statute, was the first step in bringing global justice. And so there's a new dimension needed. And I think this is a great opportunity to try to crack that code and bring international justice to another level of engagement where a nation state is, in fact, putting at risk other nation states by its inability to curtail what's coming out of it and putting at risk the others.
So meanwhile, Somalia is like a vacuum. It's a lawless place. In fact, Al-Shabaab, which is a terrorist organization affiliated with Al-Qaeda, is on the border with Kenya. And your government, Judge Matuka, invaded Somalia to destroy the Al-Shabaab troops just 2 years ago. Is that right?
That is true.
And
yes.
Are your troops still there, or have they?
They're still there. They're
Okay.
still there. And in fact, there's been a call from the Somali government that they should leave. But they're still there because, of course, the argument that the Kenyan government has is that it has to protect, because that's the border between Kenya and Somalia, so that it has to protect that border so that, incursions are not renewed again. And, of course, you're aware that there's been quite a number of attacks, sporadic attacks, especially churches. I've never understood that, though. And it's been attributed to Al-Shabaab. And so, of course, our argument is that, and we feel as a country, and I think that is what has been, stated quite severally by several people, that Kenya has also helped in the fight against or rather bringing down piracy by ensuring that they do not get any routes, any passage to...
But what I think I'm hearing is that until Somalia has an effective government, a rule of law, international justice helping out, the pirates are going to continue to flourish, and the drug traffickers and the organized criminals, because that's what happens in a failed state. And it's not just Somalia. You've got Yemen, and now the pirates are breaking out in some weaker states on the west coast of Africa. And so it sounds like just prosecutions isn't enough. There has to be a more holistic approach. Just security isn't enough. We have to have something more holistic. Well, let's then take advantage of this opportunity to close things down because we're out of time. I'll say that Hollywood has always glorified piracy, but in today's broadcast of Talking Foreign Policy, we've seen that piracy is a scourge that continues to vex the international community. And that's the version of piracy that you're going to see in that new Hollywood movie with Tom Hanks, Captain Phillips, which should be refreshing. If you want to weigh in on the discussion or suggest a topic for an upcoming broadcast of Talking Foreign Policy, please send an email to talkingforeignpolicy@case.edu. That's Talking Foreign Policy, all one word, at case.edu. Let me thank our outstanding panelists who have come from far and wide. So again, we have Judge Matuka, who has come from Kenya. We have General Dallaire, who has come from Canada. We have Prosecutor Beakery, who's come all the way from Mauritius. And then not so far away was Milena Stereo, who came down a block from Cleveland State. Thank you all. I'm Michael Scharf. You've been listening to Talking Foreign Policy, produced by Case Western Reserve University and WCPN 90.3 Idea Stream.
Talking Foreign Policy is a production of Case Western Reserve University and is produced in partnership with 90.3 FM WCPN Idea Stream. Questions and comments about the topics discussed on the show, or to suggest future topics, go to talkingforeignpolicy@case.edu. That's Talking Foreign Policy, all one word, @case.edu.